And we're live. Good morning, Brussels, or at least this part of Brussels that is in the room. Good morning, everyone. Thank you so much for joining us this morning on behalf of BILC. Yeah, that's how we say it. European Consumer Organization. We are very happy to see you here today, and we're very happy to be here today at another CPDP to discuss the matters that for us as a consumer organization, most importantly as a civil society, or are very close to our heart in this particular panel. Simplification for whom? Unpacking the digital omnibus and its effects on consumers. So to get things started, because it's bright and early, and if you're all here today at this hour forsaking your morning sleep and your early coffee, that is definitely because we have an amazing panel with stellar pool of speakers, and that's who you came to hear, and definitely not me. So I'm going to go start into the presentation. So on my right-hand side, we have Diana Vlad Kalcik, Team Leader for Regulatory Simplification at DG Connect, European Commission. On my closer right, Finn Murstad. I hope I got it right. I try, but I always fail. Apologies. Director of Digital Policy at the Norwegian Consumer Council, a proud BIOC member. On my left-hand side, I have Andrea Sherban, Policy Council at Future of Privacy Forum. And my further left side, Romain Robert, the Acting Head of Digital Policy at the EDPS. So great panel today, and we're going to go right ahead and start. So before we start with a burning grilling of questions, I would like to maybe ask our speakers for some just quick thoughts. So it's a provocative question in itself already, simplification for whom? So if you can already help us start to unpack the digital omnibus in let's say 3 minutes. Let's try to keep it to it. I don't see any timer around, so we'll try to stay on point. So maybe Diana, we'll start with you. Maybe we'll go that way and see how it goes. Thank you.
Thank you so much. Thanks for having me. It's really great to speak to all of you. And I think I really appreciate your starting question of simplification for whom, because of course the general narrative is of course simplification for businesses and then European businesses in particular. But I'll tell you how we've started in my team. So what my team does is that we do all of the digital simplification. This means the AI omnibus, the digital omnibus, and the forthcoming digital fitness check. And then my role is essentially to pull all of these things together into a coherent strategy and to support my colleagues who are doing the substantive work. But the starting point for us was maybe, and I've been giving this example before, in particular in my team, there's a sentence in the Draghi report, in the preamble of the Draghi report, that essentially explains that Europe is really at the crossroads. I cannot quote it from memory, but crossroads, and there's a pressure to build up our competitiveness. And then the sentence follows and explains that it's not just for the sake of competitiveness, it's also a promise, or rather a must to do, so that we can still deliver on our social model and our values. And I think for us in my team, this is the mandate that we were given. It's look at how we can optimize the digital rules so that we can continue preserving those fundamental rights and promoting fundamental rights and having the same high standard of consumer protection. And I think here it's also a moment, let's be proud, and I think for digital regulation as well, let's be proud of what we have. It's not going away from it, it's rather making it better. And this is the mandate that we were given. So I think in terms of simplification for the digital omnibus, it's a pretty clear focus point. This was the data and AI. This is what we've been really reflecting on in depth, and of course there are a couple of other pointers there. But the narrative and then the attempt in the Commission's proposal is to say, first, let's make very clear and predictable what the AI rules are, and then I think we were making jokes before on stops for omnibuses and trains and so on. So the first station has been reached with the AI omnibus. And second, if you want to be competitive and build your responsible AI solutions in Europe and not import them from outside, you actually need a framework for accessing data and processing data, personal and certainly industry, non-personal data, first and foremost, potentially, in a responsible and well-framed and predictable environment. And this is why we have the Digital Omnibus with several ingredients. One, and it's a big one that we don't talk about as much, and we probably won't talk today, is on the Data Act and all of the industry data sharing practices. The second one is targeted amendments to the General Data Protection Regulation. And of course, we have a couple of other pointers. But this is what we wanted to achieve: responsible AI development in the European Union through targeted simplifications here, targeted amendments here. And we've done it through several things, and I'll stop and open the conversation. I mean, there are some measures where we look at really saving direct costs, so which sort of simplifying regulations. But what industry have told us is that digital regulation, even though some will say it's a lot and it's been growing exponentially over the past years, I think I would argue that it was also necessary to have the regulations that we have. And this is really a moment to clean it up and to understand where it is predictable and safe enough, both in terms of how do I apply the rule as a company so that I don't take regulatory risks where it's unnecessary, but also in the way that I can enforce it as an enforcer. So we have these two elements as well. One is, can we further the harmonization in the single market and bring that clarity, apologies, and predictability? And then the second element, can we reinforce the enforcers? And you see this in particular in the AI Omnibus, and maybe we'll talk about it later, where that's a focus in and of itself. And there's another element which is supporting innovation in protected experimental spaces. So we have sandboxes and real world testing and so on and so forth. But these are the ingredients. And I think there's this journey of, we want these solutions to be built by European companies in Europe, but to develop that responsible innovation also for European consumers. So let me leave it at this.
Many thanks, Diana. On that, we're already been the regulator right now, so maybe we'll start now with Romain. Maybe your 3 minutes, because I hear a lot of provocative tidbits already there.
Is it working? Yes. Good morning, everyone, and thank you for the invitation. In a nutshell, I will not reread and reproduce the joint opinions adopted by the EDPB and EDPS, because I'm sure you've read it at least 3 times. And if you didn't, I invite you to read them again. As you know, EDPS and EDPB adopted 2 joint opinions, one on the AI Act and the other one on the AI Omnibus, and the other one on the Digital Omnibus. So everything is in there. I will not replicate it, but I would like to frame how this opinion was structured and which kind of compass was used to drive the opinion. There were 3 compass, 3 objectives that the opinion was analyzing. The first one was the need for simplification and whether actual simplification was reached by the omnibuses, the AI and the digital. Do we see a simplification there, or do we see a complexification of what was already not clear in the text? You will see in the opinion that we had some doubts about some modification brought, for example, to the GDPR, for example, with regards to the obligation to inform the data subject. This exemption is so complex to read, for example, that we were afraid that it would just bring more complexity than simplification, for example. So that's the first objective of this opinion. The second one is definitely the level of protection and safeguard for the data subject. In this regard, I would just maybe mention the new provision regarding the access request and the right to have access to your data that was already reviewed by the Commission in this proposal, where we thought that this redrafting of the access right was not really very fortunate, let's say, and was not really reaching the level of protection that was granted in the current text. So that's the second compass that was analyzed by the joint opinion. And the last one was legal clarity. And there again, I invite you to read the opinion and maybe to read between the lines, and we'll see that the EDPB and EDPS consider that the legal clarity, which is really well needed for SMEs and all companies in the EU to do business with a legal framework which is very clear for everyone, was maybe not the objective which was reached and met by these omnibuses, where we had some doubts, especially as regulator, when you think that even DPAs, the first authorities that are supposed to apply the text, are not really sure to understand the meaning of the omnibus. I think it could be a little bit concerning for all the industries as well, but also for the individual to understand the text. So if the first one in line, the authorities, are not really able to understand what are the changes about, I think it may be concerning as well. So it's just to rephrase the three compasses that were used during the opinion: legal certainty, not so sure; simplification, some doubts; and a safeguard and a level of protection for data subject as well. Some concern about this as well. That's what I would frame it in a nutshell.
Okay, thanks, Roma. Finn, from a consumer perspective, help us unpack this.
Thank you. Pleasure being here. Congratulations on being awake and here this morning. I got woken up at 5:30 from the fire alarm in my hotel. So for me, it's already midday. So I'll try to, I want to take a little bit of a step back because I don't live in Brussels and I'm not in a part of the EU discussions on an everyday basis. So when trying to prepare for this panel, I was trying to see, okay, what are we actually trying to achieve, right? I hear words like simplification, and you ask the question, simplification for whom? So what is the purpose, right? If you look at how the digital market has developed, what we are seeing, and I'm talking from a consumer perspective, are incredible harms being levied at consumers, at citizens, and at society as a whole. That's why we started with the GDPR in the first place, to respond to the growing concerns about what unchecked use of personal data could do to our society. Right? Then we had the Cambridge Analytica scandal, and you can discuss how much did that impact. But it impacted to some extent, and we can discuss how much. Impacts our elections. It impacts our teenagers on social media. It impacts people who every day are being targeted with personal advertising, with scam advertising. Today, 29 consumer groups are taking action against Meta, YouTube, Google, and TikTok for scam ads on their platform. And this has been allowed to proliferate because the companies have been allowed to operate with impunity. So, simplification for whom? We need simplification for consumers. To create certainty, to create a base level of respect for fundamental rights. That is not happening today. That's where the discussion should start. And I worked as an industry lobbyist, not in the tech sector, but in the energy sector here in Brussels 10, 15 years ago. And what we talked about then was we need a level playing field. Yes, we need a level playing field also in digital. But we don't create a level playing field by not enforcing the laws that we have, because that is the reality today. And we've not allowed the rules we have to actually work. So if you were going to ask me, how do we simplify the rules? Yes, we make it much easier to file legal complaints. We make fast-track mechanisms to deal with cross-border complaints so that we can have a legal certainty much faster than we have today. And in the digital world, that is much more important because the tech moves so quickly, the business models, they evolve, and you can capture the market so well. So what we've seen as a result of this lack of proper enforcement is massive power concentration, where some few companies are breaking the law with impunity, where the fines are just considered the cost of doing business. So simplification would mean to have fast-track mechanism, algorithmic disgorgement. Let's delete algorithms based on the illegal collection of data. That is simplification. When I speak to companies, and I speak to companies all the time, all they ask me, Finn, can you please contribute to enforcing the law so we can compete on a level playing field? That's what they're telling me. So we need to turn the whole thing around. And obviously, as you then probably can deduct from this outset, I'm not particularly optimistic about the simplification, because I also represent a transatlantic consumer dialogue, a network of 75 consumer groups in Europe and the US. And I can promise you it's overwhelming support in the US among the people to have strict privacy controls in place. So this is not like just a European issue. There's transatlantic unity on having strict standards for data protection, for example, which in turn will create a more level playing field, because what's happening today is that these companies are getting away with whatever they want. We filed lots of legal complaints. The first complaint under the GDPR we filed was against Google. And you would imagine that what we documented was pretty simple. We documented how they used dark patterns, deceptive design, to grab more data from their users, using their dominant already dominant position to get a data monopoly. That was 2018. And accidentally, my first child was born then. And I'm seeing this little human grow up. And now she's in second grade, 8 years old. And we still don't have a decision in Ireland on this first complaint. That is what kills innovation. That is what kills competition, because companies are getting away with this. So we need to turn the whole thing around. And just as a last point, on the definitions on data protection, which I'm sure we'll go into.
Quick last point.
This stuff, we've been waiting 8 years to create legal clarity. So if we change the definitions now, we have to wait 10 more years to get legal clarity, in addition to creating lots of loopholes for industries that we want to regulate. So we need to take a step back, and I promise you, we are not fulfilling our role as responsible as actors in society if we don't deliver proper protections for society, which in turn will create more competition and more innovation. Thank you.
Many thanks, Finn. The unpacking needs unpacking of its own. Well, Andrea, on that, we just heard the transatlantic angle being brought up. So, as FPF, what is particularly your take on this?
Yes, now it's working. So it's a good energizer to start with. So first of all, thank you so much for the invitation to join the panel. I've already taken a couple of mental notes that perhaps we're going to probably, most likely, discuss further. And I have to say that I've noticed today is a full day of lots of discussions and perspectives on the Digital Omnibus. But I guess we have to start the morning with something very, very strong and energizing. So I'm very happy to be part of this conversation today. So at Future of Privacy Forum, or FPF for short, surprisingly, apparently people know us by FPF, but not Future of Privacy Forum, or vice versa. Now everyone knows us by both of them. So we have been looking and trying to observe all of the developments happening currently. And we have shown quite a big interest in understanding how these developments fit not only within the current framework that we already have, but also in a broader picture, in a broader level, how they interact with other frameworks, not only at European level in the wider the digital rulebook, but also how they interact with other legislations and frameworks around the globe. What we noticed particularly for the current conversations, is that the pressure for simplification is not actually happening in a vacuum. Organizations are implementing an increasingly dense and interconnected digital rulebook where obligations overlap across multiple frameworks and sectors. So part of the debate may actually be less if the European Union regulates too much, and more about how coherent and how these rules are actually in practice. We noticed that there are lots of questions that arose around duplication, implementation timelines, overlaps, operational complexity, especially that, at least in the AI systems and technology, these cut across multiple sectors, both in legal and technological areas. At the same time, there is also a need to distinguish between the targeted simplification and the revision of foundational concepts. So the simplification and around the governance processes or implementation could definitely improve predictability for organizations, but looking at core concepts of the GDPR might not necessarily produce the same legal certainty that we hope for. Particularly given that technology, but also the interpretation of rules in courts and in guidance is ever evolving and very quickly, I might add. So perhaps one of the broader questions emerging from the current discussions focuses more on how to maintain this coherence across the digital rulebook. But anyway, I will stop at this for now, so I hope we can dive in more into this in the following conversations.
Many thanks, Andrea. Many thanks, everyone, for such an enticing start. Indeed, very energizing for getting us off on this morning. That definitely beats the espresso doppio at the door if you can get through the queue. That said, well, Diana, maybe back to you. A lot to unpack here. So we've heard a lot of concerns from Finn and Roma, but also from Andrea here, that is precisely the point. The Commission does talk a lot about the need for speed on this, but is this speed really necessary? Is this an urgency? Is there clear shortcomings that the ongoing discussions are pointing out in these rules? And are those precisely the ones that we're addressing? And most importantly, do you see that burning justification for both the content and the procedure that we're taking right now? What's your take on that?
No, thank you for that question, and thanks for all your contributions. I think, I mean, I know that polemics and opposition are maybe more enticing to observe, but I don't think this is where we are. I mean, on the EDPS opinion, to be fair, we've read it like a very, very welcomed contribution to the debate. So yes, our objective is to pursue that legal clarity, but then we need a conversation as to whether we've achieved it. This is a co-decision process that the Commission is supporting, and we're engaging in this conversation. So I think there were really important points that EDPS have made there in improving the text and improving the Commission's approach, and that is the discussion that we are engaging in now. Now, you talk about speed, and of course, I mean, we say an omnibus proposal that covers all of these dimensions. Let me still focus on data and GDPR, Data Act, and so on and so forth. I mean, the reality, the economic reality for businesses here, and I would say also for the consumers who are exposed to the products that are coming to Europe, is that, in the bubble or the realistic race on developing competitive AI solutions, a company is essentially losing opportunities, huge opportunities with every day that passes where they don't bring that product to the market. So from this perspective on whether there is an urgency to have legal certainty where we've identified or we can identify that there is a risk that the law will not be applied because it is too vague, or where there is a risk that it will not be enforced because it is too vague, I think this was part of our reflection on why there is a need for speed in the choice of the instrument that we have proposed. And then there is a coherence point as well. Now, speed is not a trade-off with quality, and we are engaging now with the co-legislator in all of this, in all of this discussion. I also want to pick up on another point which was mentioned here, that what we need is more enforcement rather than simplification. And frankly, for me, these are not opposing elements. I think we certainly need enforcement, and this for the Executive Vice President under whom I work, under Executive Vice President Virkunen, these are the two priorities, essentially. One is enforcement of the rules which are under her supervision, and I mean, the Digital Services Act is the one that I'm most attached to, but there are others, the AI Act coming in now, Digital Markets Act, and so on, and certainly GDPR within the cluster of commissioners. So enforcement is a priority, and you even see it in our proposal. So if I go to the AI Act, one of the points that we've made there is that we've tried to maximize essentially our efforts. And maybe it's a model that you can reflect upon, but the Commission is competent under the Digital Services Act, and there are certain AI products in the way that businesses speak about it that will be embedded in the large platforms that are supervised by the Commission. What we're trying to do, and we have now achieved, yes, is that the Commission becomes also competent to enforce the AI Act against those same providers. It's not the witch hunt or any of that, but it's seeking effectiveness and efficiency in the complementarity of this instrument. So that's really one of the tools through which we look at enforcement. There's a second one, and I think this is the more controversial one that we're discussing. I can still speak, maybe let me take it to my field of expertise, which is the Digital Services Act, where we were looking before the proposal and we were talking with judges and we were talking with the enforcers. And there was a vacuum of laws. They were saying, look, we can have decisions on every one of these issues, but if you don't give us laws as co-legislator, and obviously the Commission's proposing the rules, you're putting too much burden on the justice system here. So, okay, for the GDPR aspects and some other aspects in our proposal, what we're saying is we have understood that both businesses and regulators have troubles in interpreting the rules in the same way, and this weakens rules. So complementary to other support functions for and prioritizing enforcement, we also want to give back to the co-legislator this responsibility of clarifying what they meant. Did we get it right? this is the conversation that we're having. Can it be, are there maybe risks that we identify that for the worst case scenario, that we still need to mitigate for, let's do it. But the principle itself, I mean, let's not throw the baby with the bathwater, because the principle itself, that when the rules are clear, they're better for everyone. And then here we're also talking about a single market. This is not just a buzzword, it's a reality, because that is essentially the only strength, not the only strength, it's one of the main strengths that Europe has in being the biggest market in the world. So let's make it one market. Let me stop here and then come back.
Thank you, Diana. Speaking of clarifying what the rules meant, let me bring the master of guidelines into this one. Romain, did we get it right? Are we getting it right? Or are we actually throwing the baby out with the bathwater?
Thank you. But I think what Finn said was also really, also interesting. I think also that enforcement is also key, because having rules without enforcing them doesn't make any sense. In my previous experience, I was also a private practice litigator for 9 years, and I know that my clients usually ask me, what's the risk if I just violate the GDPR? And if the answer is none, they usually don't do anything. So I think the stick is really important when you just want to apply the rules. And of course, the rule has to be clear, because usually a client just go to you because the law is not really clear, but they want to know what's the risk in there. Talking about as well the simplification and the evidence base and the pace of this omnibus, you will also understand that we're not sure at the EDPB and EDPS to understand the need for such a speedy procedure, the lack of evidence of why this modification were needed was also lacking. So there was no way for EDPS and EDPB and all the DPAs to understand why these changes were needed at this stage. Why are they needed today and not yesterday and not tomorrow? But also, maybe also more importantly, why these changes were proposed and not other changes that maybe would have been a better simplification and clarification of the law. Let me give you one example. As you know, even EDPB is now in the middle of a litigation against big actor like Meta about the very important question of pay or okay. Can you pay with data? Can you use a cookie walls? This has been litigating for 8 years now, and it hasn't been clarified by the legislator. Maybe it was a good question, or maybe it was a good option to clarify instead of clarifying or simplifying other issues in the GDPR. Maybe this issue, which are pending issues, still waiting for clarification, taking resources from DPAs to clarify something that should be clarified at the legislative level and not at the court level, in my opinion, should have been better clarification and simplification than any other points. Let me also mention, for example, to be very specific, this Article 6.4 of the GDPR, which is the further use of data for other purposes. To be clear, it's not really clear what it's meant by a further use under 6.4, and therefore the use of this article is quite minimal since the adoption of the GDPR. So maybe these other issues would have been worth some simplification and clarification in the first place. But again, we were not in a position to assess why some provisions were chosen to simplify and not others, because there was no evidence-based approach and there was no impact assessment. And I know it's a big word. The lack of impact assessment of the omnibus is stating the obvious, but it was also something that was really was preventing us to assess whether this provision were more urgently calling for simplification than others. So the lack of evidence was really clearly something that we were regretting.
Speaking of which, pay or okay, Finn, is this Top Gun Maverick approach flying past all these burning issues that we really must address? Or maybe it's not so simple?
No, I just want to echo what Romain just said. We get really worried when these legislative processes that we've been a part of in the past typically take 2 to 3 years. 5 years even. So when something is rushed through in this way, we start questioning what's going on here. And when there are simple things like impact assessments, when there are revelations, and I cannot attest to it, but it was a story that the Corporate Observatory Europe compared some text from the American Chamber of Commerce to the final text of one of the proposals. there was quite striking similarity, apparently. So, and there's all this pressure also from the US. This is what the US members of TACD is saying. They are like, be strong here. Don't give in to pressure. And I'm sure there are also European companies wanting some of these simplifications, particularly the major ones. But again, just looking at what this will mean in practice from our point of view. So we've had a huge report on commercial surveillance. Back in 2020, we worked with a cybersecurity company and we mapped how data is being collected from us every day on our mobile phones and our website. And we tracked where all this data went from the apps. And we collected data from dating apps, for example, sensitive data. And you sort of assume like this data is sensitive, so there are extra protections in place. Of course, that was not the case. This data was being broadcasted to thousands of companies in real time. And all these companies, we investigated these companies, not all 1,000, but maybe a few hundred of them. And these companies are data brokers. They are part of what we call the ad tech ecosystem. They trade in our personal data every day. They make detailed profiles on us where they make assumptions about our lives, about our sexual orientation, about our political beliefs, our religious belief, our income levels, whether we're depressed or not, all these things. This is happening every day. This is being used from the commercial aspect to target people with ads when you are the most vulnerable, whether that are ads for dieting or plastic surgery or whatever, those ads will hit you. If you're a soccer, scam ads, right? These same ads will discriminate you, same algorithm, same data will discriminate you from seeing ads for certain jobs. Real example, seeing ads from certain living areas to live because you're assessed as a risk. The same data is being sold to authorities. In the US, this data is being sold to ICE to deport people. I work also with the defense. I do a presentation on this together with cybersecurity researchers for the Norwegian Army. And we talk about how this data is being weaponized by intelligence agencies for foreign operations. The same data that's coming from our apps. And so we've been working now for 6 years trying to hold this industry accountable, and we're not the only ones. Lots of other groups are doing lawsuits on this topic. We had a great victory this autumn against one of the apps, Grindr. But we're also trying to prosecute the ecosystem. We're waiting for a decision 6 years on. And with the changes that are in the Omnibus, where you change the definition of personal data, we fear that this whole industry, where they can claim that this data is pseudonymous, there's no such thing as pseudonymous data in this world. And now with AI, you can use this data in completely new ways. So what we need to do is to tighten the definitions. We should ban surveillance advertising. That would be clarity. And in the DSA discussions, we were this close to actually achieving it. But who lobbied against this? Big tech. Who made the rules vague? Big tech, right? That's why we don't have clarity, because the immense lobby pressures from these companies in the procedures in the European Union, I've seen it with my own eyes, and I'm obviously not accusing the European Commission or you for being under the pressure necessarily, but we see what happens all the time with the lobby pressure weakening these rules. And then they go and say there's no clarity. No shit, there's no clarity. You lobbied to make this unclear. And then when we do prosecute, they throw thousands of documents and legal documents, try to take out our cases on procedural grounds, which takes years to clarify. Oh, are we actually a legal entity to file this complaint? Of course we are. But they can question this and delay the process with 3 years, right? And then they hire all the people working in the Data Protection Agency. Look at Ireland, right? Hiring the Data Protection Commissioner there for Meta. So, clarity, again, we need to go back and see what do we want to achieve, right? So this is not doing anyone any services, I think. And also, of course, it does not, if this was true, right, we could have taken the time. I don't believe in this rushed narrative that the industry is pushing on AI. So, yeah. What do we need? What we need, we're talking about digital sovereignty right now, right? There's a huge push for European alternatives. So we just, and now a little product placement, if I may, published this report. where we document how companies are, big tech companies in particular, but not only, are locking consumers in. We document how they do it with technical lock-ins, exploiting network effects, all these things, right? Making it really difficult for consumers to leave. Huge impediment for competition, right? But then if the consumer is possible to break out of this lock-in, they discover there are no competitors. Because as Mark Zuckerberg so nicely put it, it's better to buy than compete. So a study by, I think, an American think tank showed that of 300 different big tech mergers, 64% of those mergers or acquisitions led to the companies just being shut down. And the companies that are not being shut down are being merged into the existing product suite. Instagram being prime example, WhatsApp another prime example, right? So we need to sort of break down the walls that keeps consumers locked in. So that's the DMA enforcement, for example. Interoperability here is key. The DSA is important, of course, and of course the GDPR, the real data portability, right? That would create dynamics in the market, that would create actual competition, and companies that wanted to innovate could actually innovate because they could get a critical mass of users much faster. But today, the big tech actors are locking us in and killing off competition. That's what we should focus on. Competition on fair terms, where consumers have real power to move. And have faith in the market. We don't have faith in the market when we weaken protections this way. So I really hope that in this legislative procedure, which again, you guys are the experts on what's going on here in Brussels. I really hope we can reverse some of these quite damaging proposals and move back to sort of enforcing and simplifying by, for example, banning surveillance advertising. That would be helpful.
Many thanks, Finn. On that, I think I have to, wow. You started a fandom right here on the site, very nice. So I guess you're gonna set up a shop outside and to give away the reports. So everyone is happy to take a copy. All our speakers will get one, that's for sure. But let me just bring Diana into this. Romain was just being very provoked about the fact that there is no impact assessment. And just the other day, one of your colleagues was actually saying on a panel that's defending that the Commission doesn't need to do an impact assessment. From what we just heard from Finn, maybe there's a lot to unpack here. Maybe we should have reduce the needs for speed. I think we all know it's the 40th anniversary of Top Gun, but still, maybe we could have, turned it down a bit and looked at this with a little more closer look. Or does the Commission have enough evidence to move on what we're talking about right now?
Yeah, so I mean, the Commission generally needs impact assessments, and we have a better regulation guidelines that indicate when we do. What we have done here is that an impact assessment essentially says we're looking at several options and then you weigh them against each other. What we have done is a staff working document that's over 200 pages long, where we illustrate not how we compare options, so that we didn't do in writing, but how we see the proposal impacting competitiveness and then also other interests at stake, fundamental rights amongst them. So that is the evidence base that we've illustrated there. Now, I feel like I need to talk a little bit about process. And then for us, in the preparation of the Omnibus, there have been quite intense consultations which went through the whole industry areas and open consultations as well, where we've had input from civil society and authorities as well. One of my maybe favorite discussions has been when we gathered, in particular, smaller European companies in a room and we did a focus group type of conversation in saying, how does this operationally impact your costs, and how can we optimize more the rules from your business's perspective. So this is illustrated and it's also documented there. But in the choice, and I think these are all valuable conversations and we should have them, but pay or okay as one example, roughly around the same time as we were preparing the Digital Omnibus, we were also advancing with the enforcement of the Digital Markets Act, and we have their decision on Meta in particular. And we also analyzed a little bit whether this is one situation where you can choose one solution for a huge company that has the type of data footprint that this particular company has, as opposed to all of the other actors on the market. And I think the answer is this needs a closer look. So in our understanding, we took a place of humility and said, this is not an omnibus type of proposal that we can make now with a level of complexities for the multiple hands in the advertising market, and certainly with impacts on publishers and any other business that has an online footprint in the world, and certainly for individuals, and for data subjects. So that has been a little bit the process before the proposal. But of course, the process doesn't stop at the proposal. And again, the conversation that I am in every day is with the co-legislators and trying to discuss whether this evidence base is strong enough and whether we are regulating here for all of those majority of cases that are benign in the use of data, and we're regulating for the worst case scenario. And I think, you've talked about the ad tech. That's definitely the one area that is most data intensive and potentially presents the biggest risks, potentially, if you don't think about surveillance and other aspects maybe. But whether we got it right for the ad tech environment, whether we've tested enough for that worst case scenario, that's a conversation that we're absolutely willing to engage in and then to see if that is right. Of course, we are supporting our proposal and arguing and explaining how for the majority of cases that we have selected, from the manufacturing industry to wherever you have over-interpretations of the law, that they've led to slightly ridiculous, sort of diabolic interpretations sometimes, and then they kill full businesses with no real risk. But then when we talk about ad tech, I think we're in a different type of position. Can I just say, because DSA and my own history, so we do have a ban, but only for online platforms. And of course, when we have profiling based on sensitive categories of personal data, which would be cases linked to the biggest vulnerabilities. But yeah, that's maybe for the coffee afterwards on how that applies.
Sensitive categories of data is always a great coffee break talk. But on that, maybe Roma on this one, do you see it? Do you see the scope for diabolic interpretations? Is this what we're talking about here? Her diabolic interpretations, that was it?
I think that's a bit of it from Latin, where you have a rule that you cannot actually comply with. So just really extreme interpretations of what cautions a business in the, manufacturing area, in a factory, for the types of collection of data they would have in transmitting or processing that data. I think my colleagues always tell me about these types of examples where there is no real risk to a data subject, but then there is an element of caution, extra caution. Am I or am I not complying with what I'm supposed to be doing? And then as a business in Europe, most likely you're going to be cautious and not propose solutions rather than take a regulatory risk and go ahead and break the law, which of course we don't want.
Yeah, we just had a very nice conversation upstairs yesterday on the interplay of AI GDPR. So what's your take on that? Is it exactly like that?
If I understand it well, just to be short, and again on the, it's like the pay okay. I just want to go back to the pay okay, because before DMA, the pay okay issue was already there under the GDPR, and it was not clear. So we have a huge litigation before the Court of Justice and National Court, taking a lot of resources for the EDPB as well, because as you know, there was one opinion, one urgent opinion, then guidelines, and now the EDPB is now preparing new guidelines to trying to clarify something that, in my opinion, should have been clarified by the legislator. It's such a democratic impact, and the way you can use data to pay as a commodity or not, and you know the EDPS is quite opposed to this idea, should be debated not at the regulatory level, but at the legislator level. It's such an important democratic debate that I think it should not be left to authorities not elected. It should be discussed at the co-legislative, during the co-legislative process. On the diabolic thing, I think that, and I think I'm hearing here a risk-based approach. And as you may know, EDPB and EDPS is quite opposed to the idea that GDPR is risk-based, it's right-based. Either you violate the GDPR, either you don't. But there is no notion of risk to be taken into account to evaluate whether you violate the GDPR or not. And that's maybe something to change, I don't know. But so far, the DPAs are not equipped to enter into the discussion of whether this kind of behavior is risky or not. Why? And I think even DPA is quite reluctant to enter into this discussion, because usually from the organization perspective, when you ask them whether there is a risk for their processing, they usually say no. So entering into this discussion is quite difficult. Either you comply, either you don't. But whether you don't comply with a low risk is not a discussion the DPAs are eager to have, in my opinion.
Many thanks, Homa. I'd like to bring Andrea on this. So back to the starting point, we've heard a lot of perspectives on how this proposal is going, should have gone, did not go. So from a bit of a zoom up perspective from FPF, from your side, what do you think on the issue of this shortcomings? Are we actually addressing the real problems, or are we ignoring the bigger ones? What's your take?
So first of all, what is also to point out to some of the ideas that were raised earlier on the timeline and on the rushed nature of some sort. So only in October last year, we had only hints and rumors of a discussion around the simplification, perhaps. And then now we are barely half of the year ending of 2026, and we have an AI Omnibus agreed on. We have opinions already coming from the council members and also from the EDPB, EDPS on the Digital Omnibus. So we can see that there is quite an accelerated way of discussing the Digital Omnibus, and now that, actually both of them, but now that we have the agreement on the AI Omnibus, of course the attention is no longer going to be divided between of them. So the Digital Omnibus is just going to go with full force ahead. Well, to assess whether the Omnibus identifies shortcomings in the GDPR, we actually should look less at political narratives and more at what is emerging actually from the regulators themselves. So enforcement trends, coordinated opinions, national guidance, implementation practices, and why not even strategies for 2026 and the years ahead, as they give us quite an interesting glimpse into what the DPAs are working on or how they're going to adapt to technology, and not only. So for quite some time, we at FPF have been working on researching what is the European Data Protection Authority's take on AI for a report that will be published very soon. So what emerged from our research is that one important point becomes very clear, that regulators are not treating AI as existing outside the GDPR framework. On the contrary, over the past few years, they have operationalized the GDPR principles in AI context through guidance, enforcement actions, and it's interesting to see that the regulators are relying on the same GDPR principles, regardless if the technology concerns LLMs, generative AI, ADM systems, and so on. At the same time, they also themselves acknowledge that there are some unresolved challenges, and we see these particularly around the scope of personal data in AI models, exercise of rights, fragmentation in governance, and compliance expectations across member states. And what is interesting, though, is that institutionally, the response so far has largely been for incremental clarification rather than the calls for foundational revision of the GDPR. And what is worth noting is that the DPAs are actively developing governance methodologies around AI systems, including life cycles, analysis, risk mitigation, safeguards, and so on. So the enforcement practice itself reflects this shift. If you look at the cases that have already emerged concerning AI, regulators do not appear to actually oppose the technology. On the contrary, they seem to focus on governance, on the issues such as on issues of transparency, absence of clear legal basis, insufficient safeguards, or failing to facilitate data subject rights. And I think there is one particular example in the recent discussions around AI systems used to generate non-consensual intimate images. So the AI Omnibus agreement already introduced a new prohibited AI practice targeting this system, which will apply from February next year. But at the same time, we already saw some existing GDPR enforcement being used in this area. So I think a couple of weeks or months ago, I think around March, a Dutch court has sanctioned X in relation to the generation and distribution of non-consensual intimate content. So this is an example of how AI-related harms increasingly sit at the intersection of multiple frameworks across the border of digital rulebook, rather than existing entirely outside the current legal structure. Also to note that recent DPA guidance and enforcement appear to indicate a growing openness towards the use of legitimate interest in some AI training contexts, provided, of course, that the organizations can demonstrate appropriate safeguards. What is also important to note is that we need to understand the bigger picture and how the GDPR is increasingly being implemented not in isolation, but as part of a much broader rule book. Organizations need to simultaneously navigate not only the GDPR, but also the AI Act, the DSA, DMA, Data Act, European Health Data Spaces Regulation, cybersecurity obligations, and consumer protection as well. So with this in mind, some of the calls for simplification might actually reflect broader cumulative governance pressures, and the challenge might not necessarily be the existence of the GDPR's core principles, but rather how they operate the duplication of and fragmentation, as well as operational complexity across the framework.
Thank you so much. I actually want to take this. I think this is a very important aspect, and I want to bring Frin on this. On precisely just yesterday, again upstairs, we were hearing a commission official saying precisely that if we had negotiated GDPR now, one of the main concerns that we would have right now on use cases would be precisely how to frame this in order to address AI as a default. And so as we see that AI regulation must build and does build on GDPR, and that effects of the change of the Digital Omnibus on GDPR may actually roll back protections that go way beyond, as Andreas said, not just GDPR, but others. How do you see the consumer harms that this changes might have? What is the consumer perspective on what these potential changes may bring, and how do you think we could have done it differently?
Yeah, good question. I think it's obviously speculating in harms. We're often told that we're scaremongering, right? 6-7 years ago, we were worried about facial recognition, and we saw how apps were making these funny services where you could take a picture of your face, and if you read the fine print, you'd see that you get this funny picture back, but in the fine print, you see they'll train their model to create face recognition. And we tried to warn about this, not only us, of course, many others too, but no one really took this seriously. We've proposed a ban on commercial remote biometric recognition or face recognition. That could have come in the AI Act. Now there's national possibilities of doing this. But no one took this seriously. Now we're seeing how the same technology from probably the same companies are being used to make deepfakes. And who's that impacting? Mainly women. And how is it impacting them? Images that they would not like to be created are created against their consent, right? That's an actual harm. But it goes 5 to 10 years down the line, right? Now we're looking at AI. And again, in our report, Breaking Free, on enshittification, a term not coined by us, we have a chapter on AI. Because what we describe in our report is how, because of these lock-ins that we have, because there's a monopoly of services, because we can't move, because there's no competition, services are enshittified. So they're made worse. Companies collect more data about us, they fill our feeds with ads, and they exploit us, they make the services more addictive. They collect more data, and so it goes. If we look at AI, estimated $2.5 trillion are being invested cumulatively till today or 2026. That's like an estimate. Who knows where it will end? Estimated income in 2026 from generative AI, $80 billion. It's a massive gap between investment and expected return on that investment. And we also know that AI has a few characteristics that makes it different from previous, technologies, that it's extremely energy intensive. So an energy cost will drive, so every time we use it, energy cost goes up for the company. And also you have really expensive chips that only have a lifetime to 3 to 5 years and then need to be replaced. They are also expensive. So the costs on AI are going to be massive. And there are investors and huge companies, they want their money back. So how are they going to do that? We should be really worried about that. Because what we're seeing now, AI being rolled out, integrated into companies that are already vertically integrated, locking in consumers, locking in public authorities, and locking in society at the same time. What we're already seeing is a massive increase in license costs for companies and public authorities. We need to do something there. For consumers, on the other hand, we fear that AI is the next frontier of enshittification because they need to earn money. So we're already seeing ads being placed into ChatGPTs. My AI on Snapchat has been there for years, collecting data on the user's chat to target advertising. So we're going to see, I think, a massive exploitation. And of course, exploitation with an AI is potentially much more dangerous than the kind of exploitation we've seen so far on digital services. So I think that we should really try to learn from history. What these companies are doing is not in our interest necessarily. They fight for their own interests, and that's money, and that's perfectly fine. But it's our right to define the terms of service, not the other way around, right? So I think that we should really be critical and have a bit of a precautionary approach. I think that's we're a big market in Europe. I think we can do it. And I do talk to AI companies in Europe, and they just want fair competition. And I think they tell me, just enforce the law against these companies that are consistently breaking the law every day. Then we can compete on fair grounds. It's a bit of a repetition of what I've already said, but I think it's really important to have this in mind. Let's learn from history, and let's look at these companies. And of course, in a digital sovereignty discussion, this is even more important. And in terms of solutions, one of the things we outline in the report is the power of public procurement and public policy. So we just had a roundtable last week back in the country that I know the best, but this should be done in all countries, really. We discussed with computer engineers, trade unions, companies, interest groups. How can we create more competition through open standards, open source, interoperability, and data portability, right? If the public sector, with often a big public purse, starts investing in these sort of standards, we can have much more. And it could be modality, right? It doesn't have to be a system all at once. We should look in that direction where we also get lots of other gains. More competition, more choice, more sovereignty. For consumers, generally more competition is a good thing. So we should turn this around. I'm repeating myself, sorry. But we should probably open the floor soon for comments and questions. That would be fun.
Definitely, that's upcoming. Before, just a quick word for Romain on the interplay between GDPR and AI, because I know AEPS is doing some work on precisely trying to clarify this angle. How do you see it in terms of potential harms for consumers? And this is something that is concerning regulators in Europe right now.
Just to be quick, because I think we have to open the floor, I guess, but as you may know, the EDPB is now working to have common guidelines with the Commission. So we are doing the work as well. Just to be clear, EDPB and DPS is part of it, of course, which just contribute a lot to the work of the EDPB, is playing the game and just really adopted guidelines, joint guidelines with the Commission on the DMA, also adopted guidelines on the DSA, interplay with the GDPR, is now preparing joint guidelines with the Commission on the interplay within the AI Act and the GDPR. So really, we also part of the simplification process, trying to make it clear for the actors involved how this EU digital rulebook can interplay with each other. On the consumer side, I'm not sure that I see any benefit for the consumer in the AI and the digital omnibus, I'm afraid, because I don't see any improvement of the right in this proposal. At the same time, it was not the objective, as we understand, of the Commission. The objective was simplification and legal clarity, most of all for businesses. The only maybe simplification that we can see, and it's really an interesting debate, I think, and it's just interesting discussion, is the Article 88B, which is the introduction of the signaling to allow the consumers and the users to express their choices directly through not a CMP and all the cookies fatigue, just to reduce cookies fatigue, is an introduction of this new provision to make it mandatory for the controllers to respect the choices of the users expressed through a standardized scheme or standards adopted by the industry and published by the Commission. So this is really a simplification in our understanding, because we all are tired of consent fatigue, right? So we want to have a new way to express choices and to see these choices respected. And I think in this respect, the real simplification in the Digital Omnibus is really, in our opinion, Article 88B, which is the new introduction of consumer choice, and finally a standardized and harmonized and easy way to express choices and to see them respected by the controller when you navigate the web.
A quick reply for the Commission on this. So do you see that this Digital Omnibus has a zero benefit for consumers? What is your take on this?
I think, how can I answer? Look, I'm really grateful actually to Romain for mentioning the cookies provisions. And I think today you'll have a panel where my colleagues will explain more specifically about this. And I think that's absolutely right, is that I think we have two elements for consumers. One is that consumers are not just exposed to products and services, they're also part of it and they should be beneficiaries. So I want to maybe pick up on your points on AI and, for consumers in Europe, it's very clear that they will be exposed to AI products and that there is a race to the top, to the let's say to the top on the quality or the convenience of the AI products that they will be seeing in every single one of the services and products that they will be purchasing. So for us, I think the question is, how do we do it in the European way? And this is, again, the conversation that we're trying to promote and to have from the European Commission's perspective with our proposal. And then we continue that conversation. On your other points, I think this is, again, extremely important, and that's work that's coming, and you will see a tech sovereignty package that will look at cloud. We will have procurement-related aspects. And we also have infrastructure built in the European way. So we are looking at environmental aspects as well, in particular in Nordic countries, but not only. These are all elements that we are trying to put together in a coherent and consistent approach to AI that bears our values and our objectives. But the way that data is used needs to be one of them, and that having that legal certainty that protects both fundamental rights and promotes the ability of businesses to build something for the benefit of consumers is also part of it. And on the cookies aspects, absolutely. I mean, it is the one clearly targeted measure directly to consumers because it is about their directing convenience in exerting their rights in a responsible or in a fundamentally informed way of making their choices online rather than clicking through. There's another aspect to this, which is enforcement. So part of our proposal is not just that we will have this sort of what I call password manager-like tools where you can make your choices on the consent that you give or you don't give on an online on a website, but it's also the fact that we want to bring these tools into the governance of the GDPR. And maybe this is a conversation we could have had and haven't yet on the effectiveness of our governance systems. These are rules that they are under the e-privacy directive in a rather fragmented way and quite weak from several perspectives, including the ability to enforce and the coordination across the single market, whereas the GDPR is the place where we have all of the mechanisms and the strength of the fines and the strength of the DPAs to actually enforce these rules. So there's all of this reflection on how consumers can benefit it, and I just really wanted to stress this because we've been talking about enforcement, and it is one of the things that we've kept in mind in making the proposals.
Many thanks. Before we open the floor to questions, we started 5 minutes late, so with the blessing of the organization, I'm going to push it 5 minutes into the coffee break, if that's okay. Just 30 seconds for Finn. Do you see it as a race to the top?
No.
Short and sweet, or at least just short. And on that, unless anyone else wants to jump in here with 30 seconds, I guess we just open the floor for questions. Okay, that's great. Thank you so much for a great discussion. So maybe for benefit of time, we can take a round of questions at the same time. So we'll take a few. So if anyone has questions in the room, I see 1, 2, 3. So maybe microphones are in order, right? Yeah, there we go. So I would say this lady here in the front first, and then the two gentlemen there in the back. Over there. The lady in red, as Krista Berg would say. Lady in red. There you go. Could you please just state your name as well and your affiliation for the record?
I'm Eva Lang, and I'm here privately, so no affiliation. But I have a question for Diana. Because of the change of definition of personal data. Now, instead of being able to judge what is or isn't personal data based on the data itself, Now it's supposed to depend on capabilities of the controller, which I can't judge as well as a consumer, which can change as the capabilities and access to information changes for the controller. And this affects whether GDPR even applies and whether I as a consumer think I even have rights. So I wanted to ask you, how would the change of definition for personal data help me or simplify things for me as a consumer?
Many thanks. We'll take a round and maybe take all together. So 2 gentlemen in the back.
Excellent. Okay, thank you very much for that excellent panel. Loved it. And thank you very much, especially to Finn for this fantastic campaign. I loved the video. I encourage everybody to share it. It's just wonderful. Here comes my question. My name is Jan Schallerberg. I'm the chair of a little committee in ISO that's called Privacy by Design for Consumer Products. And you alluded, Finn, to the fact that we need more open standards. I've been running around for a year trying to get more other stakeholders, especially consumer stakeholders, into that group. I've been trying to call people. I've been mailing a lot of people. No reaction from any of the consumer organizations. So I'm seeking advice from the panel here. How do I get involvement? And I know you have a lot of important work to do, and I totally accept your prioritizations in these areas. But this is the first international ISO committee that has consumer in the title, and I can't, for the sake of it, get any involvement of consumer organizations, and I'm really frustrated.
digital@bilk.eu. Please do. The other gentleman in the back was another hand raised. Maybe not anymore. Okay, there you go. Okay, maybe we take a second round after. Almost there.
Hi, thank you so much for the discussion. One question I have coming from the US is, from our observation of the simplification process, it looks like many of the arguments we're seeing for simplification are identical to the arguments that big tech companies are making in the US to argue for deregulation. I'm wondering how you're threading the line there, how you're sure that this actually is in the benefit of people and small businesses that are trying to enter the competitive market and not big tech companies. And also wondering, is there anything in the simplification process that addresses the cost that it will be for small businesses that were making the effort to comply with the original rules that now are essentially penalized by new entrants into the markets that do not have to meet those same standards?
Many thanks. Maybe just there's 2 more hands here. Maybe we'll take those and close the round here. So.
Thank you. I am Katarina Alvizu from Rabobank, addressing a question to all panelists. Final takeaways. Which one of the changes that target the GDPR Omnibus would you like to see going forward, and what not? I know, of course, that Romain made some comments earlier, and there's the joint opinion, but still I would like the final remark. Thank you.
Many thanks. That already takes care of my last questions for closing statements, so very much efficient. Last question?
Yeah. Well, thank you so much for the insightful discussion panel. I have a more of a specific question regarding the GDPR amendments. So I'm Miruna Janina Kojokaro. I'm a student from the University of Groningen, and I'm specializing on technology law. And my question is in relation to Article 2 GDPR, specifically the the proposed exception, para K. And I'm wondering, because it's for the processing of special categories of data for AI development and AI training. And my question is, if this article were to be adopted, also having in mind recital 33, which aims for the residual processing of such data, how do you see controllers defining what disproportionate effort means for them?
Thank you very much. So we have 5 minutes to answer. Noblesse oblige. So we start with Diana. Personal definition of data. Definition of personal data, Article 2, a lot to unpack. So maybe we start and then we'll let the other speakers take as well.
So on the definition of personal data, the intention from the Commission's perspective here was to build on court cases that have brought certain clarifications. And then on this basis to say where the individual cannot be re-identified as the entity who receives that data for the time when you cannot re-identify them, you're not bound to apply the heavy burdens of the GDPR, essentially. So this is the intention. But this is limited in time, limited within the means and then the whole framework here. So the intention from the Commission side is not to create vulnerabilities for the consumer, that de facto you cannot be re-identified, that third party cannot reach you, cannot affect you directly, so you would be shielded from any issue. Again, this is the biggest point of conversation, I think, for us, whether we've mitigated for all of the extreme cases, and it is part of the discussion where we're supporting the co-legislator in finding the right balance. It was not, in our perspective, the objective is not to modify the definition of personal data, but to bring that level of clarity as well. I think then from my notes, there were questions on the deregulation versus simplification element, and maybe I need to get back to the process here. So the selection of the proposals from the Commission side come from areas which were flagged in court cases, and we felt comfortable enough to bring those clarifications and harmonize across the board. They come from EDPB opinions and EDPS contributions, of course, on the understanding and interpretation of the law as well, where we felt that it was better to give that legal certainty where it's not non-binding guidelines, which are, but it is in the law itself. And then certainly from discussions, first and foremost, with European companies and the type of gameplay that where we've gone through all of the steps of how they are impacted. So this was our process. Now, of course, there might be aligned interests with other types of players, but if you look in practical terms and in actuality, if we talk legal certainty, when we reach legal certainty, it is those who can't afford to take the legal uncertainty, as I think Finn was pointing to. If you look at the 10K, 10Q forms from certain companies, you can see that fines for non-complying with regulations are embedded into their business plan, and they know that these will be cost absorbed, which is not something that a European company can do. That is our objective, and that is what we are focusing on. And I think Miruna was asking about the AI training and the residual use of special categories of personal data. I think the point there is that there's an actuality that there might be special categories of personal data, even if they're hallucinated by the AI tool. This is the specificities of these types of technologies. So what we are seeking to do is to make sure that there is a process that's very clear for the controller when this happens. A process that leads, with the last sentence in that article, that you never, ever, ever regurgitate that data. You don't expose it in any case. So it is, in a sense, a risk-based process due diligence that is explained in the article. Of course, some points need to be principles-based, as the GDPR is, and elements on proportionality will be there that will benefit from the clarification processes that the GDPR has. Now, take all of this. So I am not a GDPR expert. I should have said this from the beginning. My role is to pull my colleagues together and then deliver this for the co-legislator to adopt it. So this is my interpretation in my lines, and we can speak at the coffee break about the details of it. And I hope I haven't forgotten anything that was addressed to me.
Many thanks, Roma.
Just quickly to answer to the question of our American colleagues, I think there is no evidence that that simplification is no deregulation, and there is no even evidence that this simplification is going to help the European companies. That was confirmed by Eurotech Alliance during a panel as well in January, when this organization representing the EU companies confirmed that it didn't see the advantage for EU companies of this simplification. On the Article 9K, I'm sorry to say that, again, in our opinion, I think we were quite clear that we didn't really understand the added value of even the way to apply this article, which is basically saying you should not process data when it's in the process of an AI model, but if you do, just please try to delete it. You must delete it. If you can't delete it, you should try to delete it. If you can't delete it, then you should maybe keep them, that just prevents that people can read it. That's how you read this article, and I think it's not the way forward to write an exception to a prohibition to process sensitive data. I think it was quite clear if you read between the line of the opinion as well. And on the last part of the definition of personal data, I think the opinion is quite clear as well, that we don't see the added value of changing, and I think Finn made it very clear at the beginning of this panel, to change the definition has been subject to litigation and Court of Justice decision for the last 10 years, and to have a new definition is going to lead us to a new 10 years of litigation and discussion about a new definition. And I think we don't really not need that in the simplification debate right now. We need to simplify, and also to simplify the case law. Having a new definition is going to open the Pandora box for another 10 years of discussion before court and before DPAs, and I think we don't want that.
Finn?
Okay, I'll be quick. I think the reality for consumer groups is like a lot of other civil society actors on the digital teams. When I say digital teams, they typically consist of one person, and they're in charge of broadband, privacy, copyright, and then probably food safety. Right, so I think that sadly that's the reality. So it's not the lack of will; it's just that most of the groups are swamped and under massive pressure, and we see big tech moving in on consumer groups, providing funding. That's not good. So we definitely need standards, and I completely agree. That's why we talk about it. But we need to avoid, we're sort of designed to fail a bit. Enforcement authorities as well don't have enough staff to do the job properly. But yes, let's talk in the break again. We have spoken before. Thank you.
Thank you. Andrea?
Thank you. Just a quick note, I think, in one of the questions of what we would like to see moving forward. So I would say it's not necessarily, at least on my perspective and only for my side here, it's not necessarily about what I would like to see moving forward into the amending process, but more like I'm concerned with how the process itself is. Sure, there are a couple of welcomed achievements in the omnibus and in the proposals overall, and I've seen it quite a lot in the opinions that have been either issued officially by institutions or leaked from the opinions of the member states on the topic of the Digital Omnibus and the Omnibus, that the overall concept of simplification is rather welcomed. But of course, there are some concerns, especially when it comes to core GDPR concepts. And I think that reopening them or bringing them up or revisioning them, as how you want to call this process itself, may actually be triggering more challenging disputes later. And it's quite important because we are at a time now when we are just building all of these jurisprudence and all of these guidance on concepts that are apparently now up for discussion. So that's something to think about. Thank you.
Many thanks. And before we wrap up, I'll just ask 30 seconds of each of you for some closing thoughts. So looking towards the future, and after everything we've discussed, it's been a lot. How do you see what's coming ahead of us? And are you optimistic? Not so much. Maybe we'll go back to the original order. So Diana first.
Yeah, thank you. I mean, I think we've also I forgot the question. I think for me, the way that I understand it now, the Digital Omnibus remains a very important step towards bringing that clarity. And part of my job is to support the conversations such as the one today, and definitely with the co-legislator. The second step for me is the digital fitness check, where we're really going to look at the overlay of regulations, their interplay, and the effectiveness of their joint enforcement. And I'm very excited about that, and having a conversation maybe in a year's time or less about it with this group and others. So let me leave it at this, also with some advertising on my side.
Many thanks. Roma? 30 seconds.
Okay, yeah, I think it's really an exciting exercise. I agree with you, Diana, that the digital fitness check is going to be really important, that's for sure. And last note, I invite you to maybe read the concept note paper of the EDPS on the digital clearinghouse, when the EDPS wanted to suggest that to have this discussion within an umbrella, not an organization, but a forum where all digital regulators could just exchange and discuss about this matter, especially when they are on the same subject, like PROK and everything, because everything is at the core of DMA, DSA, AR regulation, and digital regulation, to make it easy as well for regulators to understand they have to discuss and to exchange best practices, but also cases, information, and how to make this EU digital rulebook work in practice. So digital clearinghouse is really one of the ideas of the EDPS. In the last 5 years, this just came to our minds to make it happen.
Finn.
I think we have discussed this so much, and I think that it's we just need to remember who we're working for. And I think primarily we're working for the fundamental rights of our citizens to create the markets that they deserve based on those rights. And that needs to be front and center. And I think enforcement, the DFA, I really look forward to that. And then using the opportunity now with, sadly, we have to use the opportunity with increased global instability to make sure we create, there's all this overlap with digital sovereignty and competition, and we take advantage of that opportunity that we have now to create proper alternatives and more competition and innovation and choice for consumers. Thank you.
Many thanks. And last but not least, Andrea, to close us off.
Well, we are living in very exciting times, that's for sure. And I can only say that I'm mostly curious about how everything is going to unfold in the coming months. Well, what is my main takeaway from all of this is to keep an eye on enforcement, because evidence is there and we need to definitely look at that. And with this, just a kind reminder that the FPF report is going to be published very soon. So, of course, there are more information about data protection authorities' take on all of this. Thank you.
2 brand new reports. You heard it first here. Thank you so much to the panelists for a great discussion. Thank you for coming. And now, of course, now you can, for still 20 minutes, enjoy the coffee break. Thank you so much for soldiering on with us this morning. It's been a pleasure. And you can always learn more about our work at bilk.eu. Thank you so much. Have a great conference.